Are you the same Ramsey Ibrahim who was placed on deferred adjudication in 2024 CR 3624 for the offense of theft of service $2,500 to $30,000 on December 3rd, 2024 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
On or about the 10th day of February 2025, in New York County, Texas, William Francis Ibrahim, who had been in there failed to conduct himself properly in a proper and orderly manner, according to the supervision officer of the County Community Corrections Department, in violation.
How do you plead to that? True or not true?
What's not true?
I'm sorry, I can't hear. True. All right. Did you understand by pleading true to violation of condition number 4, the court would find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There we go.
State, what are you requesting?
Guilt.
And defense, what are you requesting?
Judge, we're requesting my client be given an opportunity and allowed new information. I'd like to.
All right. And you say your client would?
He would like to go.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony? All right. If you all could whisper in the box, please. Just whisper. All right. Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right. You're whispering.
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Ramsey Ibrahim.
All right. Defense.
Ramsey?
Wow. So, two incidents happened after court. And, I was found, guilty.
Pled no contest. Technical unplaced on probation.
Well, through that incident, I lost the job. And I didn't see a therapist. They tried to just decide my past. With depression and anxiety.
Judge, may I talk to my client for just a moment?
Is there any mental health issues or anything of that nature?
Yeah.
All right, probation. I'm going to order the theft course.
There's no justifying.
All right, so what happened?
Lashed out.
How?
By not. I was 13, but not close. It's 22 hours.
Any objections to the court review and the court summary?
My client could be allowed to apologize for court review summary.
No, I want to review the court summary because then I can have more information about what's going on because he's not telling me everything.
I wrote an email on that.
No. Any objections to the court review and the court summary?
No.
It's sent by email, and what I will tell attorneys, I receive emails from Officer Abrams, TAP evaluations, PSIs, but I don't read them or open them until I ask both parties if they have any objections to my reviewing it, because I know it's here. So since defense counsel doesn't have any objections, I am going to open the court summary and let me read it, and then I'll let you continue. All right.
My client could be allowed to continue.
Yes.
I apologize so much, so sincerely. Now it's stressed. I was in a really low spot.
But according to the court summary, let me explain something to everybody. I understand that people sometimes they're angry at their situation. Sometimes they don't want to accept responsibility for the situation. I understand, right? So, but according to the court summary, they're saying that this isn't the first time that they've had an issue.
Yeah, that's basically the only notable time that we're
Well, no, not only notable time. I'm just telling you what they say. This is what it says. It says this is not an isolated incident. He has consistently exhibited defiance towards his probation officer and field officers, refusing to comply with basic probation requirements and making it clear that he has no intention of changing his behavior. So that's before the letter. That's what that seems to imply to me, that this isn't the first time. So they have the letter, and they're saying that when field visits are conducted, it's the same,
Ma'am,
similar things.
yeah, so like, dude, again, we- I'm very, very sorry. This won't happen again, but as far as the field visits were concerned, it was thrown into agitation when the officer came.
No,
Hold on.
it's fine. I'm just trying to figure out what's
I
happening.
understand, Judge. What my client is saying, before this motion was filed, or he came and talked to me, I don't think he really full understanding of what he was looking at and what the court may end up doing. After I talked to him, and after I really informed him what he was looking at, what the court might do, and after hearing Sterling say what they're requesting, I think you can see my client's I want, like, what Ramsey was talking about, Judge, is he had a bad idea. He pled true to a condition I've never seen on an NCR before. Of just not fail to report, not the rest of it, fail to conduct himself in a properly and orderly manner. He's pled true to that. He's responsibility for that. And he has promised that he's going to make a change. I think since I have had the opportunity to talk to him about realistically what he's looking at, should he not, in the rest of his 3 years of probation, and the conviction, and the 2 years day for day, his attitude has shifted in a remarkable way. He's willing to apologize to each one of those officers, suspended, apologize to the court, apologize to the prosecutor if need be. I just want to make sure that the court understands his changing attitude. That's why we're here. It's his attitude to the court. Was.
Sincerely, my apology.
All right, so my question is, and back to my question. So, stated in the court summary, this is not an isolated incident. So when they say it's not an isolated incident, I'm taking that to mean the email that you sent, right? So let's not even talk about the email. So they're saying you have consistently exhibited defiance towards his probation officer and field officers. And the field officers are the people that go out to see you, because I require that their field visits. And actually, your probation, I don't do cookie cutter probations. Your attorney will tell you that.
It's true.
Your probation that I gave to you, in the big scheme of things, the conditions that I've given people, it wasn't that much. You didn't even have restitution to pay, because I guess people received their items.
Sure.
But you were only 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, field visits one time for 3 months, and 200 hours of community service restitution in the theft course. That's all. Yes.
Sorry, Judge. What my client is concerned about is that yesterday he made a payment to pay off his community service hours.
Oh no, that's fine.
Again, that's what he's trying to say. And you're looking for a job, and you're pay the restitution in full before the graduation. That was part of the bargain to pay the restitution on front. That's why it's not a probation. So, again, in this past week, I want to make sure he's registered for the theft class, has his community service hours off in full. He has reported you today. He has apologized for his behavior. I think that in the past weeks, the MGR was issued. He's gotten the message.
Martin, how old are you? 40? Okay. All right, is there anything else?
I want to give one opportunity. Sure. Talking. Just what?
Yes, I'd like to just hear the emotional that I mean, I am honestly sorry for having conversations where I've been spoken of. Uh, yeah, to attitude. I mean, you can see it completely. Practice of reason of our please give consideration to allow just get back on track and not I'm not good on all our conditions. Absolutely not. I was frustrated with the situation and lashed out.
All right, so let me explain something. So now let's get to the letter that you wrote. It takes a lot to send an email to somebody. And what you said
Yeah.
is, I'm literally cast aside and blacklisted on the same level as effing rapists, pedophiles, and effing real felons. You're in felony court. Sometimes people think that, oh, I'm not like other people who are charged with crime. And then you say, I hope a prison convict breaks out, rampage rapes all the aforementioned, and give them AIDS. It takes a lot of anger to write that and to send it.
So after without denial from the perspective, yeah,
And that was sent on March 26, 2025.
just find that level of right. I'm embarrassed and having to hear it. It was at my lowest point. And it's just so yes, I was angry.
Oh, States, you may continue. You're excused. You may continue to confer.
Yes, I'm telling you, that was a point of just ultimate love. It's not an excuse. It's just a future threat.
Judge, my client would like the opportunity, if he's allowed to continue his probation, to apologize. And he'd like each one of you. If you would like to make an addition, it'd be great. I know it's usually outside. We do let you. It wouldn't be unusual for you to allow him to apologize.
I do apologize.
All right, I understand, and I understand that people are angry sometimes. All right.
Judge, we would ask also for additional information about a cognitive behavior course or an MRT course to those that may understand.
I just started seeing a therapist and talking with a psychiatrist.
I think the court clearly has reading and hearing what he wrote. So the court can see an apology, wanting an chance.
All right. In probation, what are you recommending?
Judge, court summary indicates revocation. Mr. Abraham has only been on probation since December, and although
He did sign his letter, yours truly. I think there should have been another thing other than yours truly, maybe with regards or something.
great judge, the court summary says revocation. I would say that he could benefit from some courses like the cognitive behavior course and more connection therapy. There has been, I know that the court reviewed the court summary, and you can see that there was some positive urinalysis that were waived by the state. However, he did produce a copy of his prescriptions. No prescription for alcohol, so that is something that we would have to really hone in on. But as far as the other positives for actual substances, I do have prescriptions for those. And he did provide the receipt for his community service hours. The community service hours were paid to Feeding America, so I would ask the court for taking that into consideration. Other than that, Judge, all I have.
So are you asking for revocation? I understand the officer's requesting revocation, correct?
That is
All right, thank you.
And if I could, Judge, I understand why the officer I would ask for courses. I would ask that the court allow my client to issue a full apology, email, handwritten, or in person. Ever wants to do that? If my client is allowed to apologize,
To all of the above.
he is taking this quite seriously now after our conversation. Whatever the court would like to do, we'd ask that he
This is what the court is going to do. The court is finding violation of condition number 4 true. The court is going to find you guilty. The court is going to revoke, sentence you to 2 years in the state jail facility, give you credit for any time served, and the court will retain jurisdiction. And you can explain to your client what that means.